Before we dive into the detailed legal analysis, I want you to consider this. If a police officer asks you, "Where are you coming from?" during a traffic stop today, what would your immediate, instinctive response be? Share your answer in the comments below. This will frame the rest of our discussion. Introduction. The seemingly simple question with complex implications. In the fabric of everyday American life, interactions with law enforcement, particularly during traffic stops, are a common reality. Among the myriad questions an officer might ask, one of the most frequent and seemingly innocuous is, "Where are you coming from?" On its surface, it appears conversational, a mere filler during the routine exchange of documents. However, beneath this simple inquiry lies a complex intersection of constitutional law, practical policing, and individual rights. Your answer, or decision not to answer, can significantly alter the trajectory of the encounter, potentially extending its duration, escalating its intensity, or even providing the justification for a deeper investigation or search. Understanding the legal landscape surrounding this question is not about promoting hostility toward law enforcement. Rather, it is about empowering yourself with knowledge of your Fourth and Fifth Amendment rights, the operational goals of policing, and the practical strategies to navigate these situations safely and legally. This article provides a fully detailed, legally accurate guide based on United States law, Supreme Court precedents, and widely accepted legal advice. Our goal is to inform, not to instruct, and to emphasize that while you have robust rights, the safest physical outcome is always the top priority. Part 1. The legal foundation, your constitutional rights. To navigate this question effectively, one must first understand the bedrock principles that govern police-citizen interactions. 1. The Fourth Amendment, protection against unreasonable searches and seizures. A traffic stop is considered a seizure under the Fourth Amendment. For it to be legal, an officer must have reasonable articulable suspicion that a traffic violation or other crime has occurred, is occurring, or is about to occur. The initial stop must be justified, e.g., speeding, broken taillight. Once the stop is made, the officer's detention and questioning must be reasonably related to the mission of the stop, typically addressing the violation, checking license and registration, and ensuring roadway safety. The critical legal point: questions that extend beyond the scope of the stop's original mission, without developing new reasonable suspicion, can turn a lawful detention into an unlawful one. The Supreme Court has grappled with this in cases like Rodriguez v. United States, 2015, which held that police may not extend an otherwise completed traffic stop to conduct unrelated investigations, like a dog sniff, without additional justification. 2. The Fifth Amendment, protection against self-incrimination. The Fifth Amendment guarantees that no person shall be compelled in any criminal case to be a witness against himself. While typically associated with formal custody, its spirit is relevant here. You have a right to remain silent. Answering questions about your travels, your companions, or your destination could potentially provide information that links you to a location, event, or group under investigation. 3. The Terry Stop Doctrine, brief investigatory detentions. Based on Terry v. Ohio, 1968, officers may briefly detain an individual if they have reasonable, articulable suspicion of criminal activity. During a Terry stop, officers may ask questions to confirm or dispel their suspicion. The question, "Where are you coming from?" is often a tool in this investigative toolbox. Part 2. Why do police ask this question? Understanding the officer's perspective is crucial for an informed response. The question is not random. It serves several potential purposes. Building rapport. It could be a neutral, conversational opener to put a driver at ease. Assessing the situation. Officers are trained to look for signs of nervousness, inconsistency in stories, or other indicators of potential criminal activity, e.g., drug transportation, DUI, outstanding warrants. Your demeanor and answer are being observed. Developing reasonable suspicion. An evasive, contradictory, or implausible answer can contribute to the officer's reasonable suspicion, potentially justifying a longer detention or a request to search the vehicle. Gathering intelligence. Information about travel patterns can be useful for broader criminal investigations. Part 3. Practical strategies and scripted responses. Your response should balance asserting your rights with maintaining a calm, non-confrontational demeanor. Safety and de-escalation are paramount. Option 1. The polite and brief answer, lowest risk of escalation. If you have nothing you wish to conceal and prefer a straightforward end to the encounter, you can give a simple, honest, and non-detailed answer. Example: I'm coming from having dinner at a friend's house, or I was just at the grocery store. Pros: often satisfies the officer's casual inquiry, maintains rapport, and can lead to a quicker conclusion. Cons: you have waived your right to remain silent on that topic. If your answer is somehow inaccurate or misconstrued, it could be used against you. Option 2. The polite deflection, asserting rights calmly. This is the method most frequently recommended by civil liberties attorneys. You acknowledge the officer, but do not provide substantive information. Example: Officer, I don't answer questions. Am I free to go? Or, I prefer not to discuss my day. Is there a problem with my driving? Why this works: it clearly invokes your right to remain silent without being rude. It also asks the pivotal question: am I free to go? This requires the officer to either end the detention, if the original mission of the stop is complete, or articulate a reason for your continued detention. Key nuance: the Supreme Court in Salinas v. Texas, 2013, suggested that in a non-custodial setting, like a routine traffic stop, you may need to expressly invoke your Fifth Amendment right. Simply remaining silent is not always enough. Saying, I choose to remain silent, or I don't answer questions, is that express invocation. Option 3. Asking a clarifying question, engaging without committing. This tactic seeks to understand the reason for the question before deciding how to answer. Example: is that relevant to the reason I was pulled over, officer? Pros: it can reveal whether the officer is just making conversation or is on a fishing expedition. It puts the onus back on the officer to justify the line of questioning. Cons: some officers may view this as slightly confrontational or evasive, which could prolong the stop. Part 4. What you absolutely should not do. Do not lie. Providing false information to a law enforcement officer can be a crime, obstruction of justice, in many jurisdictions. Do not be rude or aggressive. Arguing, yelling, or refusing to provide basic documents, license, registration, proof of insurance, will escalate the situation and likely lead to arrest. Do not voluntarily offer elaborate details. Oversharing can lead to follow-up questions and inconsistencies. Do not consent to a search. If asked, do you mind if I search your car? You have the right to say, Officer, I do not consent to any searches. This preserves your Fourth Amendment rights. They may search anyway if they have probable cause, but you have not given them permission. Part 5. State and local variations and the role of pretextual stops. It is critical to remember that while constitutional law is federal, its application can vary. Furthermore, the legal doctrine of pretextual stops, Wren v. United States, 1996, allows an officer to stop you for a minor violation, e.g., a faded license plate frame, if their true motivation is to investigate a more serious crime, e.g., drug trafficking. The question, where are you coming from, is a common tool in such stops. Knowing this underscores why your response matters. Part 6. Special considerations. Border zones and immigration checkpoints. Within 100 miles of a U.S. border, including coasts, Customs and Border Protection, CBP, operates under different rules. At internal checkpoints, questions about citizenship and travel origins are standard and generally permissible as part of the immigration enforcement mission. Passengers are also seized during a traffic stop and have similar rights to refuse to answer questions. Recording the interaction. You have a First Amendment right, in all 50 states, to record police officers performing their duties in public, as long as you do not interfere. Clearly stating, Officer, for the safety of everyone, I am going to record this interaction, can sometimes encourage professionalism. Conclusion. Knowledge as empowerment. The power dynamic in a police encounter is inherently unequal. The officer has authority, training, and the weight of the state behind them. Your primary tools are calmness, knowledge, and clear communication. The question, "Where are you coming from?" is a pivot point. There is no single right answer for every situation. The best response depends on your personal risk tolerance, the specific context, and your assessment of the officer's demeanor. By understanding that you have the constitutional right to remain silent, that the officer's time to detain you is limited by the mission of the stop, and that your politeness is your best armor, you can navigate this common scenario with greater confidence and security. Always prioritize safety, comply with lawful orders, like providing your license. And remember that legal disputes are best settled in the courtroom, not on the roadside.